Hey everyone, welcome to my YouTube channel. In today's session we are going to discuss about marriages, but specifically we are going to point out church marriages. However, we are going to start with marriages, talk about the various types of marriages, then after talk about the church marriage, after we point out the key elements that can make a church marriage to be valid. Are we together? So we're going to start with what is marriage and then we proceed. So, a marriage, this refers to the voluntary union between one man and one woman. However, some people may say that a marriage, it refers to a legally created bond between one man and one woman to the exclusion of others. They are all correct definitions. So, you should also note that not all persons have the capacity of creating a legally valid church marriage. So, a person below the age of 18 years cannot create a legally valid church marriage. For there to be a legally valid church marriage, a person must be of 18 years and above. And this person must create what we call all the formal requirements needed for there to be a valid legal church marriage. Marriage was also defined in the case of Hyde versus Hyde. The spelling of Hyde is H-Y-D-E. H-Y-D-E. So, in the case of Hyde versus Hyde, the same spelling, the court defined marriage as the voluntary union between one man and one woman to the exclusion of others. Basically, this case means that it has to be voluntary. Marriage shouldn't be forced. It has to be one's own choice, voluntary. That's why in Uganda, they normally say that a person above the age of 18 years, this person is an adult and this person can make his or her own choice. Meaning that if this person, let me say, even if this person of 18 years is forced into marriage, then this marriage is not lawful or is not valid. Why? Because this marriage is forced. It's not voluntary. This marriage must come from one's own willingness. Are we together? One's own willingness to enter into that legal marriage. So if a marriage is not voluntary, if at all it's forced or if at all it's caused by any other factors like duress and fraud, then that marriage is not valid. Let's go to the various types of marriages that we have in Uganda. The first one, we have church marriage. These are the marriages conducted in churches. The second one, those are the civil marriages. These are the marriages conducted in the office of the registrar. The third one, we have Islamic marriages. The fourth one, we have customary marriages. So those are the four types of marriages that we have, and those are the four recognized types of marriages that we have here in Uganda's jurisdiction. Now, let's start with the church marriages. Let's try to know the preliminaries of church marriages. Let us know the requirements, the essential key requirements that are needed so that there is a legally church marriage. When we look at Section 20 of the Marriage Act, provides that marriages may be celebrated in any licensed place of worship by any recognized minister of the church. So basically, under this section, it shows that not every place or not every church can carry out a valid church marriage. So note this, that for there to be a valid church marriage, number one, there should be a licensed place of worship. Meaning that that church must be licensed. And if it's not licensed, then this means that that place can't carry out a valid church marriage. Number two, there has to be a recognized minister of the church. Not all pastors or not all bishops or not all people can carry out a church marriage. This person must be recognized by that church, must be a recognized minister of that church altogether. So if at all the minister or that person is not recognized as the minister of that church, then that person cannot carry out a valid church marriage altogether. So basically section 20 is like an open eye of what a church looks like. Number one, it must be licensed. Number two, must be carried out by a recognized minister of the church. So meaning that if at all, number one, the church is not licensed, number two, it's not done by the recognized minister of the church, then that marriage is void ab initio. Are we together? So this section is like an open eye on what is required for there to be a valid church marriage. So the first requirement to establish a valid church marriage, number one, we have residence. Here, the parties must be residing in the same parish, and these people must be known to the society. And the banners, like the banners, must be published there, and it has to be published in the entire parish or in the entire society where they live. Meaning that every person where they live, maybe the parish or where they live, everyone must know. And when we look at section 10 of the Marriage Act, it provides that at least one of the parties of the marriage must have resided in a district which a marriage would be celebrated at least for 15 days. So, meaning that you can't just come into a new district and conduct a marriage. The requirement is that at least you must live in that place for at least 15 days. I think at least one party to the marriage must live in that area where you guys are going to marry from for at least 15 days. Are we together? So this is one of the requirements that has to be proved. The second requirement is publicity. Here the banns are entered in an official register and then published in a loud manner. And basically, when you look into churches, these people who intend to marry, the pastor normally calls them out in front of the church and they introduce themselves, they talk about themselves, both actually the man and the woman, they all talk about themselves. So basically here they are trying to make the people aware that these people want to be, they are soon going to be married. So this is an initial step whereby at least people must know that these people are going to get married. Are we together? And if any other person who doesn't want these two people to be married, then they are also given an opportunity to step in to say, no, I don't want these people to be married because of so, and this person must give his or her own reason as to why these two people shouldn't get married. So you see that publicity through giving that information to the public that these people are going to get married or are soon going to get married, it really helps a lot, so that number one, you can trace the consanguinities, number two, you can trace the ambiguities, number three, it's also provided by the law that these people should be declared in public. And another thing that you should note about publicity is that the real names should be the one that is given in the public. Are you seeing? You should use the real names. The real names are the ones that are supposed to be given while doing publicity, informing the public about the people intending to get married. So we have some of the cases that illustrate this requirement of publicity, and the first case is dancer versus dancer. Dancer versus dancer. The spelling of dancer is D-A-N-C-E-R versus dancer, D-A-N-C-E-R. The same spelling. Maybe something that I haven't talked about is that in family law, you'll find most cases having the same names. So when I said dancer versus dancer, just note there the same names. So in dancer versus dancer, so in this case, Jasmine was a legitimate daughter of Mr. and Mrs. Knight. When Jasmine was 3 years, Miss Knight began to live with Mr. Roberts, by whom she had children. All the children, including Jasmine, were known as Roberts. She continued, Jasmine here, Jasmine continued to be known as Jasmine Roberts even after Mr. Roberts died. And on the banns during when she was going to get married, they were named as Jasmine Roberts. Later, her husband petitioned for a decree of nullity adjuring undue publication of banns, because Jasmine was supposed to be Jasmine Knight, not Jasmine Roberts. That was the argument of the husband. Now, the court held that there was no undue publication of banns, since everyone in the parish knew the name of Roberts and not Knight. So basically, the holding of the court was that the entire society knew Jasmine as Jasmine Roberts, not Jasmine Knight. This removes the other principle that real names should be used. The mere fact that the society and everyone knew the real name of Jasmine as Jasmine Roberts, then there the marriage continued and was still valid. It was not void. Are we together? But if at all a person used fake names or used any names that are not his or her own names, then the court can nullify the marriage. Another case is small versus small. Small is S-M-A-L-L versus small, the same spelling. So in this case, I'm going to use symbols. I'm going to use X and Y. Are we together? We're going to use X and Y in this case. So in this case of small versus small, X was a deserter from the army. And in order to avoid detection and prosecution, he had assumed a false name which he used in relation to publication. When they were making banns for his marriage to Y, they used those fake names that he gave to himself. Now, the court held that X had fraudulently intended to conceal his true identity, and therefore the marriage banns had not yet been properly published, and therefore the marriage was void. So in this case of this case of small versus small, it shows that X gave himself a fake name. After giving himself a fake name, he married Y. And now, later, when they knew about it, they went to court. And on going to court, the court said that the banns were not properly published in the society, and therefore the marriage was void due to that principle of publicity was not carried out. Are you seeing? So this means that if you do not use the real names, if you do not use the real names and use the fake names, number one, there won't be a valid publicity. And if there is no valid publicity, this means that the marriage is void ab initio. Are we together? So basically, those are the two cases that explain what publicity is, and explain the principle of publicity, and also explain the essence of using real names in marriages, as, let me say, using real names on banns while publishing to the public. Another requirement is sex. When we look at Article 31 of the 1995 Constitution, it provides for men and women as the persons that can engage in marriages. So which means that according to the 1995 Constitution, it prohibits man on man, woman marriages, they are all prohibited in the Uganda's jurisdiction. The only marriages that is allowed, it's a marriage between a man and a woman as per Article 31 of the 1995 Constitution. However, currently in Uganda we are facing some challenges whereby there is what we call sex change, whereby a man can be changed into a woman and a woman can be changed into a man. So I have some few cases that can illustrate about sex changes. We try to see whether these sex changes, whether such marriages are valid. The first case I have is a case of Corbett versus Corbett. Corbett, it's C-O-R-B-E-T-T. C-O-R-B-E-T-T versus Corbett, it's C-O-R-B-E-T-T. So in this case, Y, I will use X and Y again. So in this case, Y was born a male and underwent sex change surgery, after which he had lived as a woman, and after the sex change he married X. During court, the court held that the so-called marriage between X and Y is void. Why? Because Y was a man but however underwent sex change and became a woman, and therefore such marriages are not recognized altogether. So such marriages of sex change are not recognized. Basically they are void. Another case is Talbot versus Talbot. Talbot is T-A-L-B-O-T versus Talbot, it's again T-A-L-B-O-T. T-A-L-B-O-T. So in this case, a woman dressed herself as a man and she called herself John. She managed to get a woman with whom she celebrated a marriage. The next day, when the woman discovered that she had married a fellow woman, she did not seek to nullify the union but continued living with her. However, later she petitioned to court to declare their union a nullity, of which the court granted and held that such marriage was void from the start. So basically you see that same-sex marriages are void. Number two, sex changes, any marriage that was conducted due to sex change is also void. So that's the position of the law in Uganda's jurisdiction. Another requirement is discovery of impediments. Well, if I can go deep into this, impediments basically means that these people must not be related anywhere, either by blood or by relative or by any connection between these two. These two shouldn't be connected at all. That's why under church marriages, they normally announce 3 times before this party can marry each other. I would be there. They publish into the public 3 times before these people can get married, so that they can trace those consanguinities, those ambiguities between the two parties. According to Section 10 of the Marriage Act, provides that parties must not be within the prohibited degrees of kindred and consanguinity, meaning that these people shouldn't be related at all, either by blood or marriage altogether. So the case I have there is a case of Bruno. So in this case, the plaintiff, who was Bruno Chiuwa, sought for a permanent injunction against the marriage between Ivan Serunkuma and Juliet Namazi, claiming that the two belong to the same clan, that is the Ndiga clan, and therefore it is prohibited under the Chiganda customs for these two people to marry each other. So the court, based on these Chiganda customs, and declared that these two people shouldn't marry each other because they are from the same clan. So this case brings out this element of consanguinity, in that if these two parties are in the same, either same clan, same marriage, or they are related by blood, these people shouldn't be married. So if marriage happens and yet these two people are related by blood and are related by marriage, then that marriage can be declared by a court void. Are we together? So this is also another element that shows whether the church marriage is valid or not valid. Another thing that you should note is that the church marriage must be between 8 o'clock and 6 in the afternoon, and in the presence of 2 or more witnesses besides the minister. And if there are no witnesses to the marriage, then the marriage is void. Well, that's all about the church marriage. We've looked at what church marriage is. We've talked on the elements or the preliminaries of a valid legal church marriage. And we've talked about some of the elements or requirements, and also we've given some cases to explain the principles or in regards with the elements or the requirements. And if you find this video helpful, kindly please share to your colleagues so that they do not miss out. Like and subscribe to the channel so that you do not miss out for more sessions. Thank you very much for viewing. See you. Sign out.